tenants in common, ownership by tenants in common, and it was interesting. All right, are you guys with me?
Mhm.
Can you see what I see?
Yes.
All right.
Yes.
I'm just going to bring this up. I've got my own notes. So I'm just going to go through, we're going to start with probably one of the most confusing offer to purchase and contracts out there, to the extent that when one of our agents called the Real Estate Commission's legal hotline to ask them about it, the guy said, I don't know. I don't know what this form is for. All right, so this is the offer to purchase a contract for new construction. Now, it's really important that we read this opening bolded section, which I encourage you guys, virtually all of the contracts will have right at the beginning when you use this contract or when you don't use the contract. So I'm just going to read it, and then we're going to start putting some spin on that. First of all, before I get into this, the bottom line is this. This form is used when the builder owns the land and the builder is funding the construction. That's the essence of this form. That's what you want to remember. If the builder does not own the land or the builder is not financing the construction, then you do not use this form. It's a really weird form. But this form is designed for use when the seller of a new home is or has engaged a licensed contractor who is constructing or will construct a spec or custom single family dwelling on land owned or to be owned. I mean, could they make it any more confusing? Bottom line is, if they own the land, the seller, and the seller is either the builder or the seller is hiring a builder, and it's either a spec home, speculation home, or it's a custom home that they're building for someone on land that they own, then you should use the form. However, you should not use this form if, one, the seller does not or will not own the land to be conveyed, or two, the buyer owns the land, or three, the buyer will provide financing for construction. These are not and statements. If one or two or three apply, then you do not use this form. So again, you do not use this form if the seller does not or will not own the land. Where that could be is a buyer is purchasing property from somebody else, or maybe the buyer already owns the property and they have hired someone to build a house on it. That's new construction, but you would not use this form. That's going to be a completely separate outside of real estate. Because let's think about this for a second. We deal in real estate. We deal in real estate, and houses are considered real estate because they're attached to the land. I know we're going back to pre-licensing, but this is the essence of it. And because the house is attached to the land, it is considered part of the real estate. So therefore we can help buy and sell that real estate. But if a buyer owns land and someone is constructing a house on it, well, that construction is not real estate. It's like they've asked someone to build a car for them. So we're really not involved in the actual construction of the house because it's not real estate. Does that make sense? And it doesn't mean we're not going to get paid based on the value of the land with the house. It just means we're not involved with that. That's going to be a separate contract with the builder that the builder will have with the buyer that's separate outside of us. It's outside of us. So goes on to talk about, for valuable consideration, the receipt and legal sufficiency of which is hereby acknowledged. Buyer offers to purchase, the seller upon acceptance agrees to sell and convey the property on the terms and conditions of this offer to purchase contract, new construction, and any addendum or modification made in accordance with the terms, together known as the contract. So when you add an addendum or you modify this, It all becomes part of the contract. Terms and definitions, seller. Just as an FYI, and you might want to make this note, in any contract, if it is owned by a husband and a wife, do not say Mr. and Mrs. Steve Jones or Mr. and Mrs. Smith. You always want to say John Doe and wife Mary Jo, or John Doe, or excuse me, or Mary Doe and husband John Doe. You want to make it clear that they are married to each other by using the words wife or husband. And never ever say owner of record. Don't say owner of record. If you don't know, consult an attorney. If you can't figure it out, consult with an attorney, because you don't want to put in some generic owner of record. That could lead to all kinds of problems. The buyer, same thing. If it's a husband and wife, buyer John Doe and wife Mary Doe, or however you want. They're going to be purchasing the real estate. So far, so good. We just kind of keep plugging along. Legal description, plat reference, right? All that stuff, all that good stuff. Nothing terribly important there. Let's see, I'm trying to, there we go. Yeah, so then we get into our purchase price. Paid in US dollars upon the following terms. And then you'll note it's in parentheses, to be adjusted by allowance and change orders as defined in paragraph 3B III. The allowance, to be adjusted by the allowance, there is another form called 800A1T, which gives the buyer an allowance. It looks like this. And it's simply the allowance that says, okay, if you're building this house, what is your allowance for wallpaper? It doesn't mean the buyer can't buy more, but this is the amount per roll that I, the builder, am allowing you to spend on wallpaper, what I'm allowing you to spend on flooring, what I'm allowing you to spend on hardware for doors and cabinets, lighting, etc. It's the allowance sheet. And so that purchase price may or may not be adjusted based upon the allowance or change orders as determined in the schedule of allowances addendum. So far, so good? I don't want to get anybody lost. All right, cool. Okay, so then we go on to initial earnest money deposit. Same thing, initial earnest money deposit. So again, this is what the buyer's agreeing to pay for the house. And this is in total. Now remember, this form is only being used because the builder or the seller owns the property and the builder is financing the construction of the home. It's important to remember that. If the buyer is financing the construction, we would not be using this form. So here we've got a builder that they don't have their own contracts for some reason. God knows why, but they don't. And they own the land and they are going to finance the construction. The buyer is then going to pay for the entire house. They're going to pay for the entire house, but they're not going to give the builder all the money up front, because think about it. Why would I give a builder, if I ask the builder to build me a house and we've agreed that, you know, with the allowances and with the purchase price, he's going to sell me the house for $250,000, which includes the cost of the land. I'm not going to give him $250,000 up front, because if I do, he could take the $250,000, walk away and not build the house and steal my money. It actually happened to my sister. My sister gave a builder money and halfway through the project, he disappeared and they were left with a half-built house. So we're not going to give the seller all this money up front. We're going to give it to them on a draw. And they're going to get this money when we have the official closing. When we have the official closing. Is the buyer putting down an initial earnest money deposit? Just like normal. Nothing different there. Is there an additional earnest money? If there is, then make sure that it is, and this is true of all additional earnest money. It's not just this contract. That it is by cash, bank check, wire transfer, ACH transfer, electronic transfer, money order. It cannot be a personal check. Additional earnest money in all cases, in any contract, additional earnest money can never be a personal check. And just as an aside, we never accept cash. Don't ever let the buyer give you cash, because if they give you cash, by rule, we have to put it in our trust account. We don't have a trust account. So, right, so no cash. So again, additional earnest money timing of the essence. Is the seller financing this? Probably not, but they could be. Is there a building deposit? And we're going to talk more about the deposit. There probably will be, because what's going to happen is the buyer is going to give the builder deposit monies as they build, and the builder's going to be on what's called a draw. So as they break ground, they'll get $5,000 to break ground. Then they'll get another $5,000 for framing, and then they'll get another $5,000 for whatever. So we're going to put them on a draw. Whenever the final cost for allowances is more or less than the allowances set forth in the contract or any addendum to this contract, and whenever there are change orders which change the cost of the dwelling, the difference shall be adjusted between the parties either prior to settlement or at settlement. The purchase price shall be the complete cost for the property. So if they go beyond the allowance on the wallpaper, or they go beyond the allowance on the carpeting or the cabinets, and that increase, then you're going to have to adjust the purchase price, because the purchase price is the total cost of everything at the end of the project, regardless of whether they were in allowance guidelines or not. It is the total cost of the property. So you may, 2 days before closing, be adjusting the purchase price because they went outside of their allowance. So just be aware of that purchase price is the total cost of everything as it is right now, not necessarily what they agreed to in the beginning. Because again, if they go beyond, if they want to upgrade their hardware for the cabinets and they add $1,000 by doing that, then that has to be reflected in the purchase price. If the buyer fails to deliver the earnest money, or should any checks be dishonored, again, true of any contract, then the buyer shall have 1 banking day to make those funds good. But understand that's 1 banking day after written notice. If the seller does not give the buyer written notice, then this 1 banking day to fix it doesn't start ticking until they get that written notice. And if they do get written notice that they bounced a check and they got to make it good, then they have to come back with cash or an official bank check or wire transfer, electronic transfer, et cetera. No more personal checks. We've lost our trust in you. And if the buyer does not deliver those funds, then the seller can terminate the contract, again, upon written notice to the buyer.
Terry, it's not a checkbox there, but since we can't take cash, would you X out the cash there as an option?
Here? Oh, you mean right here where it says cash, to deliver cash? Well, that's a good question.
Because up above it was a checkbox. Here
it was, and we can ignore that. The thing is, this is that's a great question, but remember, this is a contract between the buyer and the seller, right? If the seller says, I want cash, then be careful about crossing it off. If you do cross it off, you're going to need the buyer's and seller's permission. I think cash is a bad way to go, and I agree with you. And I definitely would not encourage them to do cash. But if they did decide to do cash and you had crossed it off, then you'd have to have the seller's permission to bring cash back into it. So I think it's best to not cross it off, but just encourage the buyer, do not pay cash. Because cash has a way of disappearing. We have no evidence that you're going to deliver that cash. You might give cash to the seller and they claim they only got $900 of $1,000 because they stuck $100 in their pocket and they didn't tell you. So I would just tell them we don't do cash, but I wouldn't cross it off. But that is a very good question. The buyer's going to be given a pre-construction evaluation period. It's basically like their due diligence period. Think of it that way. During that period of time, they're going to decide whether they're going to go forward or not. And it is a time is of the essence, and it is through 5 p.m. Now, by the way, this through 5 p.m. technically means if you have a digital watch and it says 5 p.m. and 59 seconds, then you're still in the 5 p.m. time zone, as it were. But the moment your digital watch goes 5 p.m. and 1 minute, now it's too late. So this is true of all dates associated, or all times associated with 5 p.m. is it's through 5 p.m. So it's technically 5 p.m. and 59 seconds. Now, if you're really taking it right up to that level, you may want to rethink your planning. But anyway, so that's through 5 p.m. time is of the essence. After that, if the buyer walks away, they do not get their earnest money back. They don't get their earnest money back. Okay. Dwellings, seller shall complete construction of a single family dwelling and related improvements to be constructed on the real estate. Now, by the way, this can be used for townhomes. It can be used for, it is not to be used for condos. Condos is a different beast, but it could be used for a townhome. Seller shall complete construction of a single family dwelling and related improvements to be constructed on the real estate in accordance with the plans and specs agreed to by the seller and buyer. This section right here, can you see that blue line? I'm just curious. Can you see that blue line?
Yes.
You can? Oh, cool. Okay, that's good. This section right here, you're not involved in that. That has to do with the construction of the house. You're not involved in that. The property shall mean the real estate described in 1C plus the dwelling. Remember, like I said, once they build the house and they attach it to the land, it becomes real property. It becomes real property. Plans and specifications. Anything else I want to say about that? Sorry, I got my own notes here. Make a note to yourself if you haven't. On the pre-construction evaluation period, this period of time is of the essence. Make sure that that includes enough time for the loan approval. They need enough time for the loan approval. And it's going to be different because the house isn't built yet. So the lender may have a lot of questions. So you want to consult with the lender before you commit to any pre-construction evaluation time period. And again, I want to emphasize this again. This is a very rarely used form because this form means the seller, the builder owns the property and the builder is going to fund the construction of the property. Think D.R. Horton. Think M.I. Homes. They own the property. They're financing it. They're building a spec home, and then they're putting on the market and hoping that somebody's going to buy it. This form is not going to be used very often because the odds are if the builder owns the property and the builder is financing the deal, then the builder probably already has their own contracts. They probably already have a contract to accommodate. But the reason I wanted to bring this form up and the reason it's so important is agents are using this form incorrectly because they're using it when the buyer is financing the deal, the buyer owns the property, but it's like, that's not what the form's used for. So the odds are you're not going to use this form very often, because if the builder owns the property and the builder is financing the construction, then the builder probably already has their own contract. But if they don't, then you will use this form.
Ah,
But it's important that you remember that's what this form is used for. And it's important that we know this form because, we got to know our forms. So note all site plans, drawings, floor plans, landscape plans, schedule of allowances, description of materials, and specifications lists should either be listed with copies attached as exhibits or described with specificity, title of document, date, number of pages, designer, etc., so they can be clearly identified and referenced. So we want to make sure we list out all of those things: the floor plan, the landscape plan, the drawings, everything that the buyer and the seller have agreed to, everything the buyer and the builder have agreed to, we're going to put here. Now, if you don't have room to put all that stuff here, which you won't, you can always put in here see attached or see attachment A. And then on your Word document, you'll put in at the top attachment A, so that they know that they're referencing that. Also note, it talks about the designer, all right? So the buyer just can't go get any old designer they want. The builder may have a very specific designer they have to work with. Earnest money deposit. Just like the offer to purchase a contract, the initial earnest money deposit, the additional earnest money deposit. Hey, give me 30 seconds. FedEx is here. I'll be right back. Doorbell just rang. Okay, sorry about that. All right. Anything I want to say about that? A couple of things I want to say about the earnest money. So the initial earnest money deposit, the additional earnest money deposit, and any other earnest money paid or required to be paid in connection with this transaction, collectively known as the earnest money deposit, shall be deposited and held in escrow by escrow agent. That will not be us. That will never be us. We do not have a trust account, and will be held until closing, at which time it will be credited to the buyer. The buyer's going to get credited that on the closing disclosure, or until this contract is otherwise terminated. In the event that, one, this offer is not accepted, or a condition of any resulting contract is not satisfied, then the earnest money shall be refunded to the buyer. Shall be refunded to the buyer. In the event of a breach of this contract by the seller, the earnest money deposit shall be refunded to the buyer upon the buyer's request, but such return shall not affect any other remedies available to the buyer for such a breach. All that means is this: the buyer had spent money on, I'll come right to you, Marlene, I'll come right to you. The buyer spent money on a survey. The buyer spent money on inspections, and the builder breached, only built the house halfway. And now the buyer wants their money back, but they could also sue the builder to get refunded for their inspections, refunded for the survey cost, refunded for whatever else they had put into the project. So that's what that means by any other remedies. Now they could also, I suppose, sue the seller, sue the builder, and force them to build the home. But if the builder walks away halfway through, good luck. So Marlene, did you have a question?
No, I'm sorry, Terry. I was just saying goodbye to my son.
Oh, that's okay.
Sorry about that.
That's fine. In the event of a breach of this contract by the buyer, and again, during the pre-construction period, that's kind of the due diligence period. The buyer really can't breach during the due diligence period because they paid for the right to walk away. But if they walk away after that, then without limiting any other remedies available to the seller for such a breach, the earnest money deposit shall be applied to such damages as seller may be legally entitled to recover for such breach, and the balance of the earnest money deposit, if any, shall be refunded to the buyer upon the buyer's request. Now, this is important to understand. This is different than the offer to purchase. The offer to purchase and contract form 2T, which is the one we use for virtually all resales, the one you're most familiar with, says if the buyer breaches, seller gets all the earnest money. Here, though, it's saying that the seller doesn't necessarily get to keep all of the earnest money. They only get to keep the earnest money that will make them whole so that they're not out of pocket any money. But if there's any earnest money left over, then the seller agrees to give that money back to the buyer. That is different than our offer to purchase contract form 2T. If legal proceedings are brought by buyer or seller against the other to recover the earnest money deposit, the prevailing party, that's the winner, in the proceeding shall be entitled to recover from the non-prevailing party, that's the loser, reasonable attorney fees and court costs incurred in connection with the proceeding. So it's important to remember, though, the thing out of this little paragraph right here is that the seller doesn't necessarily get to keep all of the earnest money. They only get to keep the part that they need to make themselves whole because they spent money and they need to be reimbursed. If there is a dispute, escrow agent, that's just going to be the closing attorney, most likely. I would not have my personal opinion, I would not have the builder's attorney hold it necessarily. Because typically the buyer picks the attorney to conduct closing. And definitely if the builder says, I have a trust account, I am not putting it in the builder's trust account. No, it's either going to go to, some attorney. It's either going to go to the builder's attorney or it's going to go to my attorney. I'm not going to put it in the builder's trust account. You're just asking for trouble. In the event of a dispute between the seller and the buyer over the disposition of earnest money held, we all familiar with this one. We're going to hold it, or we could turn it over to the clerk of court, and then they'll decide what happens to the money, including giving it to the state of North Carolina. Parties agree to real estate brokerage. Parties agree that a real estate brokerage firm acting as escrow agent may place the money in. Okay, we don't have to worry about that. Effective date, the last one of the buyer and the seller that signed, sealed, delivered, signed the offer. Not much else. That's standard fare, how to create a contract. So hopefully we're good there. Then we get into building deposit. Let's talk a little bit about the building deposit. So the building deposit, the purpose of the building deposit, if any, shall be to compensate the seller for the cost of making the following special improvements, whatever those might be. The building deposit shall be paid to the seller promptly upon occurrence of both the following events: expiration of the pre-construction evaluation period and receipt by buyer of documentary evidence of seller's financial ability to construct the dwelling. The building deposits are to be paid in installments. The payment shall be made according to the following. So basically, here's what this is saying. Remember, the builder is financing this deal, but the buyer has to have some skin in the game. So the buyer is going to give the builder a deposit. Just like when you go to D.R. Horton and you want to buy a D.R. Horton home, they require a deposit. They want some skin in the game. That's in addition to the earnest money deposit. That's in addition to the earnest money deposit. The earnest money deposit is there in the event because of the contract. If you breach the contract, the deposit is there to show the builder that you're serious and they can start construction. But you will not deliver that deposit to the builder until two things happen. One, your pre-construction, your due diligence period has ended. And two, the builder is providing to you, the buyer, proof that they have the financial ability to build the home. Because remember, we only use this contract when the builder is financing. So the builder will have to provide proof to the buyer, probably a bank letter, I would guess is what they would use as a bank letter, that says that they have the financial wherewithal to be able to construct the property. And upon those two occurrences, then we will release the money, the building deposit, we will release that to the seller. We might release all of the deposit to the seller, But more likely what we're going to do is we're going to release the deposit using installments. So let's say that I had a $30,000 deposit, then I'm going to give them $10,000 for them to break ground and pour the slab. And then I'm going to give them another $10,000 for framing. And then I'm going to give them another $10,000 for drywall, siding, etc. And then the final draw for finishing work. So I could do it that way. But again, it's important to remember that I'm not going to give them any of the deposit until one, my pre-construction evaluation period is over, and two, the builders provided me proof that they have the financial ability to build the home. Again, the building deposit, as I said earlier, is not part of the earnest money deposit. It is not part of the earnest money deposit. Michelle, are we recording this? Oh, thank God, because I don't want to have to do this again. My throat's already shot. The building deposit is not a part of the earnest money deposit and will be used by seller in the construction of the special improvements described above. It will be credited, the building deposit will be credited to the purchase price at settlement. The buyer is basically prepaying for the house as a way of thinking about it. And the building deposit shall be refundable only in the event of a material breach of the contract by the seller. Seller just failed to build the house or didn't build it properly. Or if this contract is terminated under paragraph 13, what paragraph are we in? I think we haven't come to it yet. Or the buyer terminates during the pre-construction due diligence period. Should the buyer fail to deliver, I'm sorry, note I made to myself. 13, paragraph 13 is discussing the risk of loss. And the risk of loss is on the seller until closing. Closing is deed recordation. So if the house burns down during construction and the buyer decides to walk away, then they get their deposit back. Should the buyer fail to deliver the building deposit or any installment thereof in accordance with the terms of the subparagraph, buyer shall have 7 days after written notice to deliver the building deposit or the installments to the seller. In the event the buyer does not timely deliver the building deposit, seller has the right to terminate this contract upon written notice to the buyer. In determining whether or how much building deposit the buyer is willing to pay, the buyer should carefully consider that even though buyer may be legally entitled to a refund of the building deposit, in the event of a material breach of this contract by seller, actual recovery of the building deposit may be difficult, time-consuming, and or costly if seller is unable or unwilling to voluntarily refund the building deposit. All that means is this. I put down a $30,000 building deposit, and I foolishly gave the seller after the pre-construction period time was over. Seller gave me proof that they have the funds to build the house. Instead of giving them the deposit in installments, I just gave them the whole $30,000 and said, "Go ahead, build." And a week into it, they walked away, and I never saw them again. Couldn't find them; they disappeared. Well, I have the right to get the $30,000 back, but what that warning is saying is good luck, because you got to find the builder. Builder may not have any money, and even if they do, they may not be willing to give it up. Now you get to go to court. So that's what they're saying. You want to be careful about the deposit you're going to make. Settlement is when we go to the attorney's office and sign everything, right? Settlement date, whatever that is. It's at the time and place designated by the buyer. The buyer designates the attorney, and the buyer, because the buyer is paying for the attorney, assuming the buyer is paying for the attorney. And this is true of all contracts. When the buyer is paying for the attorney works for the buyer. Don't let the attorneys forget that. Sometimes they get lazy and they don't want to take a side. It's okay to look at them and say, you work for the buyer. That is true in North Carolina. The attorney works for the buyer if the buyer hired them. Anything you want to say about that? In the event of a delay in settlement, the settlement date will be extended by a reasonable time. Notice there's no automatic 14 days here. It's not the same as the offer to purchase contract form 2T. The 14-day rule doesn't apply to this contract. In the event of a delay in settlement, the settlement date will be extended by a reasonable time to account for the delays because, you know, the builder, there might be rain and they just couldn't get the landscaping done or they just couldn't get something done. Unless otherwise agreed in writing, there must be substantial completion of the dwelling on or before the settlement date. On or before the settlement date. Substantial development. In other words, it has to basically be built. It has to basically be built for it to be considered okay for it to have closing. And substantial completion, this phrase is defined on the next page as to what they mean by substantially complete. Closing, we all know closing, that's when the deed's recorded. It includes the settlement, completion of the satisfactory title updates, closing attorneys' receipts of funds, disbursement of funds, deed recordation, blah, blah, blah. North Carolina has determined that closings require attorneys, et cetera. Special assessments, charge against property by a governmental agency or an HOA. Remember, when it comes to special assessments, buyers will pay proposed special assessments. These are things that are under formal consideration by the government or the HOA. So it may be that and just as a reminder, a special assessment is something like the neighborhood wants speed bumps installed. So the neighborhood wants the government to install speed bumps. What's going to happen is that the local government says, yes, we will install speed bumps, and they are going to apply a special assessment tax to just those homeowners to pay for the speed bumps. Or the HOA wants to install a pool, then they will apply a special assessment for the homeowners to install the pool. If it's proposed, it's under formal consideration to be done, then the buyer will be responsible for those costs if it is actually confirmed later on. But if it is already confirmed that the speed bumps will be installed, or it's already confirmed that the pool will be installed, and the amount of tax or the amount of additional HOA fees that will be paid is determined, even if those fees are not due until after closing, it is the seller's responsibility to pay them. So confirmed, the seller pays, even if it's not due until after closing. But if it's proposed, the buyer pays it. That's true of all our contracts. Questions? Okay, so substantial completion is just that. Completion of the construction of the dwelling in accordance with the plans and specifications and any other special provisions that may be part of the contract. It has to be inhabitable. It has to be habitable. Inhabitable, which means the same thing, which makes no sense to me. It has to be habitable and broom clean. Isn't that interesting? It's the only contract that references the word broom clean. Our offer to purchase contract does not say swept clean, but this one does. A certificate of occupancy, that is important to remember. It is not considered substantially complete. Even if it is fully built, even if it is swept clean, it is not considered substantially completed until they have also been issued a certificate of occupancy by the governmental authority, whether it's the city or the county. They have to get a CO before it's considered substantially complete. And it has to be swept clean before it's considered substantially complete. And once it's considered substantially complete, then one, you can have settlement. Two, the seller has earned the purchase price. The seller has earned the purchase price. Now understand this, punch list items could still be needed to be corrected. Punch lists are things that there's a nail pop, there's a cabinet that doesn't shut quite right, there's a nick in the wall, things like that, little simple things that the builder needs to fix. But outside of that punch list, if they have a CO and it is considered complete regarding the plans and specs for completion, then the builder has the right to their money and settlement can occur. Again, during the buyer's loan, during the buyer's pre-construction period, the buyer is going to want to get a loan, or it's not applicable. Buyer is not going to get a loan. They're paying cash. They're going to be buying the house cash. But if the buyer is going to get a loan to purchase the house from the builder, and again, I'm going to emphasize this again, remember, the builder is financing the construction and the builder owns the property. That's when you're using this form. But the buyer is then going to, once the house is built, then the buyer is going to pay for the house. They're either going to pay for it with cash or they're going to pay for it with a loan. If they're getting a loan, then they need to make sure they get that loan in place, ready to go during the pre-construction evaluation period, which is again like your due diligence period. And so nothing really changes there. Prior to the expiration of the pre-construction evaluation period, time is of the essence, 5 p.m. Buyer shall have the right to terminate this contract by delivering to seller written notice of termination if in buyer's sole discretion. Now think about that for a second. And the buyer's sole discretion is not satisfied that the loan will be approved and funded. That is an incredibly broad brushstroke. Think about that. Think about the words in the buyer's sole discretion. They don't feel that the loan is going to be approved. I mean, they could literally use any excuse. I read my horoscope this morning and I'm not feeling it. I just, in my sole discretion, I don't think this loan's going to happen. All right. Well, Mr. Buyer, you have the right to do that. Then walk away, get your money back. There you go. So it's the buyer's sole discretion. But if the buyer fails to deliver that notice, then the buyer will have been deemed to have waived this condition. They won't be able to use that as an excuse after the evaluation period. Buyer will also must provide documentary evidence to the seller that the buyer can obtain a loan. So even though there's nothing in here that says by what date they have to deliver that, they do have to provide documentary evidence to the seller that they can get their loan, because it's using the word shall. And anytime you see in a contract the word shall, it means they must. And if they don't, they're in breach of contract. So the seller could argue, the builder could argue that if the buyer does not provide documentary evidence that they can get their loan, the builder could argue that the buyer's in breach of contract because it says they shall. However, what's bizarre about this contract is the buyer's obligations under this contract are not conditioned upon obtaining or closing any loan. This whole section is just FYI. It's really kind of weird. It's not saying whether you're going to get a loan or not. All it's saying is if you're going to get a loan, you better get it, and you better get it during your pre-construction evaluation period, and you better tell the seller that you can get it. But if you can't get your loan and you don't say anything, tough noogies, buyer, you're in breach of contract. So it's important to remember that. And that's true, by the way, of all of our contracts. We no longer have any loan contingencies. No loan contingencies. You either do it or you don't. And you better tell the seller if you can't. And you better tell them before the end of your pre-construction evaluation or the due diligence period. Okay, Unless not applicable, seller's performance is contingent upon seller's ability to obtain such financing as may be necessary to perform seller's obligation. Remember, I said earlier that this contract is used when the seller owns the property and the seller, the builder, is financing the construction of the home. And the builder has to provide proof to the buyer that they have the money to build the house. Now, maybe the builder just got a bunch of money in the savings account and they're just going to use that money to build the house. And if that's the case, then you would check not applicable because the builder's got the funds. They need to provide proof. They need a bank letter that says, I've got $400,000 sitting in my savings account. That's what I'm going to use to build the house. Cool. But if the builder doesn't have that money, then they must provide proof that they can get the loan. That they can get the loan that the builder needs to be able to build the house. And then they have to provide proof to the buyer that they can get a loan to build the house. And vice versa, the buyer has to provide proof to the seller that they can get a loan to buy the house. So if the builder has to get a loan, both parties are going to have to provide proof that they can get the loan that they need to complete the transaction. And the seller's performance is contingent upon the seller's ability to obtain such financing as may be necessary to perform the seller's obligations. And the seller agrees to pursue qualification for and approval of such financing diligently and in good faith. Prior to the expiration of the pre-construction period, time is of the essence. The seller shall have the right to terminate this contract by delivering to buyer a written notice of termination if seller and here's the opposite, in the seller's sole discretion that they can't get financing. And if they can't get financing during the pre-construction due diligence period, then the seller will deliver that notice. The contract will be terminated. Earnest monies will be refunded to the buyer. Everybody walks away. No harm, no foul. But if the seller fails to deliver such notice that they cannot get the loan, then they have deemed then they have waived the right to use this as a reason that they can't build the home. So it's the same thing on the seller side. Whereas the buyer has to provide proof, the seller has to provide proof. If the buyer doesn't feel they can get the loan, they can get out. If the seller feels they can't get the loan, they can get out. If the buyer waives their right and says, I didn't say whether I can get the loan or not, well, then tough noogies, now you're in the contract. Same thing with the seller. And in both cases, the buyer will notify the seller that they can get their loan, and the seller will notify the buyer that they can get their loan. And upon proof that the seller can get their loan, and upon proof of giving that to the buyer saying, I, the seller, can get my loan, and the pre-construction evaluation period is ended, 5 p.m., then at that moment, once that happens, now the buyer has to give the seller the builder's deposit, either in draws or a chunk, a full chunk amount, depending on what they agreed to. So the moment the pre-construction period ends, the moment that the builder has provided proof they can get their loan, then the buyer has to provide proof that they can get their loan and give the seller their building deposit money so the builder can get going on construction. This contract, here's another one where, again, normally our contracts have no contingencies, but this one has contingencies, which is interesting. This contract is, and even says it, is contingent upon the seller, not the buyer, the seller, being able to obtain the following applicable reports and permits, collectively known as reports. And if they can't get them, then they can't go forward with the contract because this contract is contingent upon them getting them. Seller's got to get soil suitability test, utility availability, environmental restrictions, environmental permits, flood hazard, septic, private drinking water, zoning, restricted covenants, architectural review, blah, blah, blah. All of those reports they need to get. All costs and expenses of obtaining these reports shall be borne by the seller. By default, they do not get to pass those costs on to the buyer. That is part of the cost of construction that the builder will have built in, hopefully, to the cost of the home. And the seller shall use best efforts to timely obtain the reports and provide copies of them to buyer. If the reports cannot be obtained by the expiration of the pre-construction evaluation period, either party can terminate this contract by delivering to the other party written notice of termination no later than 5 p.m., time is of the essence, on the third day following the expiration of the pre-construction evaluation period. This is funky. If the terminating party has timely delivered such notice, this contract shall be terminated and all earnest money shall be refunded to the buyer. So think about that for a second. Normally, once the termination window ends at 5 p.m., think due diligence period 5 p.m., at that moment, that's it. We're in the contract. Now, if one of the parties walks away, they're in breach. But this contract says the seller is given a 3-day window after the termination, after the pre-construction period. Time is of the essence. They're giving them an extra 3 days to execute, to say to the buyer, I can't perform because I can't get these reports. And if they do, then they're not in breach. The earnest money will still go back to the buyer, but the buyer won't be able to sue the seller for specific performance. The buyer won't necessarily be able to sue the seller for additional funds, because this little nook right here is giving the seller a little bit of wiggle room to get out of the contract if they can't get their reports. And what's amazing is they will use their best efforts. It's such a secret out for the seller. It really is just an interesting little out for the seller. Does that make sense to everybody? What's happening there in that paragraph? I'll take your stunned silence as a yes. You're okay. Yeah, okay. And if neither party delivers such notice, then the party will have been deemed to have waived the condition, and on we go. Buyer has to be able to get insurance availability, casualty insurance. Buyer must be able to obtain the insurance set forth in subparagraph A or B below at a rate exceeding 150% of the base rate for such insurance as filed by the North Carolina not exceed. All this is saying is, if I'm going to get casualty insurance, the cost of that casualty insurance cannot be more than 150% more than what the Department of Insurance says is the base rate for that kind of insurance.
Terry, back to the 3 days up above.
Yeah.
That gives them not 3 more days to get the reports, right? Just 3 days to decide if they're going to give notice because they didn't get the reports in time. Is that right?
Well, yeah, I mean, that's a good question. Shall use their best efforts to timely obtain the reports and provide copies to the buyer. If the reports cannot be obtained by the expiration of the pre-construction evaluation period, either party may terminate this contract. Right, exactly. They have up to 3 days after the termination to say, I couldn't get the report.
But they can't, they could, even if they got the report a day or two later, they would still be in violation and could give notice if they wanted to, right?
Well, again, I'm going to put my lawyer hat on for a second, even though I'm not a lawyer. The problem with that, I understand what you're saying, Scott, and I tend to agree with you, but here's the problem. If the reports cannot be obtained by the expiration of the pre-construction evaluation period, it makes no mention of at time is of the essence.
That's true. Yep.
So they could argue, I missed the deadline, but since there's no time is of the essence, I get my 3 days.
Yep. Yep. Okay.
So yeah, but I wouldn't want to have to play that game.
Yep. Okay.
But you make a very good point. Casualty insurance, again, so the buyer cannot pay more than 150% of the base rate. So if the base rate for an insurance policy was $100, that's what the Department of Insurance says for casualty insurance, it should be $100. Then the buyer should not have to pay more than $150. If the buyer has to pay $200, then that's beyond it and the buyer can terminate. Does the buyer intend to occupy the dwelling as the buyer's primary residence? And if so, they must be able to obtain an insurance on the property with a coverage of at least an HO2 policy, broad form policy. Most common policy, by the way, is an HO3, which is comprehensive, but the buyer has to be able to get at least an HO2 policy, fire. Or the buyer does not intend to occupy the dwelling as the buyer's primary residence, must be able to obtain insurance on the property with coverage of at least equal to dwelling property 2, broad form policy, also known as a DP2 policy, without optional coverages. And again, they'd want to make sure they get all this lined up during the pre-construction inspection period. Same thing with flood insurance. If either subparagraph 1 or 2 above these two are checked, then prior to the expiration of the pre-construction evaluation time being of the essence, buyer can terminate the contract if they cannot get it. If the buyer's sole discretion, buyer's not satisfied that the buyer will be able to obtain the insurance that they need in their sole discretion, I'm not feeling it today. It's my sole discretion. Then they deliver written notice and they walk away. Street disclosures, buyer shall have the opportunity during pre-construction evaluation to investigate the status of the street/roads upon which the property fronts, as well as any street road to access the property, including whether any streets or roads are public or private. Remember, that's a material fact. We always have to disclose whether streets are public or private. It's just a requirement. They don't say how you have to disclose it, but you have to disclose it. Are the streets public or private? And so too does the builder. Now, there's no specific form for them, but they do have to disclose whether the streets are public or private. Whether any streets or roads designated as public are currently maintained by the state of North Carolina or any municipality where the property is located. Remember that streets that are designated public are not necessarily going to become public. They have to be formally accepted by either the town or the Department of Transportation. There are no county maintained roads in North Carolina. The roads are either maintained by the town, the city, or the Department of Transportation. Those are public roads. And if the builder says this road has been declared or designated as public, that does not guarantee that it will be publicly maintained. For a road to be publicly maintained, it must be formally accepted by the town or the Department of Transportation with an authorized signature of an authorized town manager or Department of Transportation manager officially designating the road. So be careful. And this is true of all, whether you're using this contract, whether you're using the offer to purchase contract form 2T, whether you're using it doesn't matter. You're buying a home from D.R. Horton, it doesn't matter. If you walk into a model home, I'm kind of getting off track for a second. I'm not talking about this form right now. If you walk into a model home, like a D.R. Horton model home or an MI model home, and the on-site sales rep says, yeah, we just found out that the streets are designated as public. Don't trust that. That does not mean that they will be public. It just means that it's under consideration to be made public. But if the builder does not build them to the specifications that the town requires or the DOT requires, which oftentimes developers won't do because they're taking shortcuts, if they don't build it correctly, then the town, although they said they'll take care of it, or the DOT said they'll take care of it, if those roads are not built to their standard specifications from the beginning, and they'll take core samples to see, then they won't designate it. They'll back out. So don't trust when you are helping a buyer and you walk into a model home and they say, and you ask them, are the streets public or private? And you should always ask, well, the streets are public. Have they been officially designated as public, or are they proposed? Are they proposed? So you, yeah, Summers Walk, my personal neighborhood, my developer did not build the streets to spec. And fortunately, the town of Davidson said, we'll take them anyway, but they don't have to. So don't trust that process. Know that they have to be formally accepted before they will be considered public. The consequences and the responsibility for maintenance and the existence terms of funding of any maintenance agreements, blah, 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 blah. Buyer shall have the right to terminate this contract. Again, time being, you know, of the essence. If the buyers in their sole discretion is not satisfied that the streets are going to be maintained properly the way they want them to. If the buyer is timely delivered money, they get their money back, right? Again, requires under certain circumstances, buyers must be provided a subdivision street disclosure statement prior to entering into an agreement saying whether the streets are public or private. That is required. If we are extending the pre-construction evaluation, the parties may, but are not required to agree to extend the pre-construction. This is the same thing as extending the due diligence period. They don't have to agree to do it, but if they do, then we'll want to put that in writing and signed by the parties. There is an amendment to modify the contract during the due diligence period. I think it would be okay to use that form to extend the pre-construction period. In the event of an extension, the settlement date shall be extended by the same period of time. So if they say, we want an extra 5 days for the pre-construction, then that means your closing or your settlement just got moved 5 days. It's automatic. It just automatically happens. You're no longer going to be shooting for that same closing date, that same settlement date. Because if you extended the pre-construction period 5 days, then you automatically extended the settlement date 5 days. Unless you scratch that out. The failure of a party to terminate his contract based upon a condition contained in this pre-construction evaluation period shall not constitute a waiver or otherwise affect any other rights. So anyway, anything else you want to say about that? Again, just as a reminder, and this is true everywhere, why they didn't do this, I don't know. There is no subdivision street disclosure document. Why the legislative body, why the Realtor Association or the North Carolina Real Estate Commission, knowing that this is a required notification under general statute that says the roads must be disclosed as public or private. Why they didn't make a form for that, I don't know, but there's no form. They just have to disclose it. Anything else I want to say about that? I have a note to myself to see an attached article. I wanted to give me 2 seconds here, guys. There is a very good article if you want to Google it. North Carolina Real Estate Commission. Just Google subdivision street disclosure issues bulletin 2015 the Victor 46 2. It's a very good article written by Stephen Fussell, who I've met before.
I feel like none of us are going to remember that.
Well, that's why you have pens and papers. Did you not write it down? That's why I spoke slowly. I'm going to speak slowly again. You're going to take a pen and a piece of paper and write this down.
I'm going to put it in the chat.
Okay. Or just put it in the chat. There you go. Thank you.
But you got to say it again so I can put it in the chat.
Oh, I do?
Yeah.
Oh, you know. See, I can't do this in pre-licensing. It's nice that I get to yell at you guys and no, I'm not yelling. It is, again, just Google subdivision street disclosure issues. Bulletin 2015 V as in Victor 46 2.
Okay.
And that should take you right to that article. It's a one pager. It's not that long. It's like 9 paragraphs. And it's a good, really good review of what are the criteria for public, private, et cetera. And you really want to know that, guys, because agents are getting in trouble a lot because there's a lot of subdivisions going up and the roads are private, but they're being told they're public. And then the buyer moves in and then they get a bill from the HOA for road maintenance. I've had a couple of agents call me, fortunately not from our firm, but other firms call me and say, my buyer just got a bill from the HOA for road maintenance. What do I do? And I said, well, did you disclose? Well, no. I said, well, then I wouldn't spend my commission money yet because you might be forking out some money. So be careful. Right. Construction, quality of construction, obviously complies with laws, regulation, codes, ordinance, good workmanlike manner, new, good quality materials. Seller changes. Seller shall not make any significant deviation or change in the plans or specs without prior permission from the buyer. Buyer can request changes to the construction of the dwelling within the general scope of the plans and specifications, consistent additions, deletions, or revisions. They can't get too carried away, though. If the buyer wants to do a change order, they will do a change order, which is a separate document in writing, signed by both buyers and sellers. Any adjustments to the purchase price. Remember, the purchase price is the total, including any changes in allowance, change orders, building deposits, et cetera, et cetera. So you just want to make sure that you address that. And again, there is no realtor change order form. That's just going to be between the buyer and the builder. Seller should provide and pay for all labor, materials, equipment, tools, cleanup, blah, blah, blah. Seller shall pay for all costs, charges, and other expenses associated with the construction of the property. Builder will get a building permit within X number of days from the expiration of the pre-construction evaluation period. They will also obtain a building permit for the construction of the dwelling. With respect to this deadline, time is or is not of the essence. Isn't that interesting that they give the parties a choice as to whether they will have a time or is of the essence or not to get their building permits. Punch list items. Seller shall notify buyer that when substantial completion of the dwelling has been done, and shall schedule a mutually agreeable time for the buyer to come in and look at the property. Buyer will then be giving, usually they give them like blue painter's tape, and they say, walk around the house, and if you see any problems, just put some blue painter tape there and we'll come back and fix it. That's a punch list item. I don't know where the root comes from. I don't know why it's called a punch list. I should invest. I don't know why. I should investigate that. After substantial completion, seller's failure to correct a punch list item prior to settlement will not be grounds for delaying settlement. As long as they have substantially completed the construction, even if they don't get the punch list items done until after settlement, that's okay. That's okay. The seller deserves to get all their money. Substantial completion. Shall not be deemed to limit the buyer's right to conduct inspections under paragraph 4. So we'll talk a little bit about that. If the seller has a delay in construction due to weather or some other things, shortages of materials, which were not reasonably anticipated, or acts of God, Seller shall give as much notice as possible as to the delay, they will figure things out as far as the settlement date. Buyer acknowledges and understands the importance of cooperating fully with seller in order to help expedite the construction of the dwelling and to avoid and minimize any delay in settlement. Blah, 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 blah. Buyer has the right to investigate the property reasonable times through the earlier of closing or possession by buyer. Sometimes builders are not going to let buyers come into the property due to insurance risks because they could get hurt. That's just going to be between the buyer and the seller. Buyer shall have the option of obtaining at buyer's expense prior to settlement a report from a licensed pest controller operator on a standard form in accordance with the regulations of the Structural Pest Control Committee, stating the dwelling has no visible evidence of wood destroying insects. But the buyer pays for that. And I love that they use the word report and they put a 0 in for the O. An official legal contract, and they have a typo. Oh, well. Not much I want to say about that. Buyers advise that the inspection report described in this paragraph may not always reveal either structural damage or damage caused by agents or organisms other than wood destroying insects. Radon inspection. Remember, less than 4 picocuries does not have to be treated. 4 picocuries or more is considered to have to be remedied. And Scott put in there, one theory is that punch list comes from when contractors would punch a hole next to each item on a project list. Oh, that's probably where it is. The hole would go through 2 sheets, creating a copy. I like that. That probably, I kind of had a feeling I had to do something with a punch. It makes sense. Buyers, again, this is true of all our contracts. If the buyer damages the property or the buyer's contractor damages the property, maybe the inspector damaged the property when doing their inspection, then the buyer will pay to have the property repaired. And then the buyer has to go back after the contractor that they hired. That's an important one. Let me point this out again. Whether this is a resale home, new construction home, it doesn't matter. If the buyer's contractor or the buyer damages the property, then the buyer will have to pay for the repairs. The seller is not obligated to go after the inspector. The buyer agrees to make the repair, and then the buyer will have to go after the inspector if the inspector damaged the property. The buyer will indemnify and hold the seller harmless for all loss, damage, claims, suits, costs that shall arise out of any contract, agreement, or injury to any person. So the inspector comes on site, the inspector hurts themselves, the buyer is saying to the seller, not your fault, we're not going to hold you accountable. That'll be, outside of that. Warranties, unless otherwise provided for herein, seller and general contractor jointly and severally with seller hereby warrant for a period of 1 year from the date of closing or the date buyer occupies the dwelling, whichever comes first. So it's a 1-year warranty. Will make all necessary repairs and corrections to the dwelling, either interior or exterior, structural or non-structural, that shall become necessary by reason of faulty construction, labor, materials, nonconformity of construction to the plans or specs. At seller's sole option, the seller or the general contractor may either make such repairs, replace any nonconforming, or pay the buyer money and the buyer can make the repairs. It is a limited warranty. It's for the benefit of the buyer only, and it cannot be assigned. In other words, if the buyer sells the house, then the warranty ends. If the buyer dies, then it will not benefit their heirs. It will not benefit their heirs. It is for the person that bought the home. It will survive closing and the delivery of the deed. This is what allows it to go on for a year. This statement is what allows the warranty to go for a year because it survives closing being deed recordation. This limited warranty is in addition to and not in lieu of any warranty implied by law, and seller and general contractor agree that they are in the business of building and selling such dwellings. Isn't that interesting? Think about that for a second. They're promising that they are in this business of building houses. That's an interesting little statement. If checked, the foregoing limited warranty shall not apply and is replaced by the attached written warranty that the seller or the general contractor has provided. Seller and general contractor shall assign and deliver to buyer at settlement all guarantees and warranties of all components comprising the dwelling to the extent the same are assignable. Buyer shall be responsible for compliance with any notice and claim procedures set forth therein. Warranty under paragraph 5A shall not extend to any such component expressly guaranteed or warranted by the manufacturer. So this is saying, you know, if the dishwasher is covered by the manufacturer, then it's covered by the manufacturer's warranty. Insulation of dwelling, it's an odd thing they put in here, but this must be by law. They had to put this in here because it doesn't really say anything other than just what they have. So buyer's representation, not much I want to say about that. Buyer does or does not have to sell or lease another property. If they do, then they're going to put the property address in there, indicating that they have to sell the property. And the buyer's other property is under contract as of the date of this offer. And a copy of that contract has been given to the seller or will be given to the seller. Buyer may mark out any confidential information. Failure to provide a copy of this contract shall not prevent this offer from becoming a binding contract. However, the seller is strongly encouraged to obtain and review the contract on buyer's property prior to accepting this offer. Buyer's other properties not under contract. Buyer's property is listed with a real estate agent. Buyer's property will be listed with a real estate agent, or the buyer is attempting to do a for sale by owner. But this contract is not contingent upon the buyer selling their other property. It's not contingent on them. It's just telling the seller, I have another property I have to sell. If the parties agree to make this contract conditioned on the sale or closing of another property, then the appropriate contingency addendum should be drafted. And the reason it has to be drafted is because the Realtor Association no longer has a contingency addendum. We no longer have a contingency addendum. So if the buyer and the seller say, okay, I understand that you have to sell your house, be able to get a loan so you can buy this house that you want me to build, that's fine. We'll make this offer contingent. They're going to have to go to an attorney to have them draft a contingency. To the best of the buyer's knowledge, there are no other circumstances or conditions existing as of the date of this offer that would permit or prohibit the buyer from performing the buyer's financial obligations. Mineral oil and gas rights. That's the MOG report. Remember, the MOG report must be given in this case. The RPODS report, Residential Property Owners Association Disclosure Report, is not required to be given because the house doesn't exist yet. But the MOG report is required to be given because it is, well, strike that. If it is a lot in a neighborhood, the MOG report is required to be given. If it is a piece of property out in the country, it is not required to be given. It is bizarre. Why they exempted raw land, I will never know, because that's where the mineral oil and gas is. But there it is. So either the buyer has gotten a copy of the MOG report, they have not gotten a copy of the MOG report, which does give them an out. If they don't get it, they get an out, either 3 days from receipt or 3 days from contract of this effective date of contract, whichever occurs first. Or this property is exempt, and it's exempt because it is raw land out in the country. But again, if it is a lot in a neighborhood, the builder has to give the MOG report. But again, if it's a lot in a neighborhood, the odds are the builder's already going to have their own contract, and we wouldn't be using this contract at all anyway. Yeah, like I said, buyer pays for proposed special assessments. Buyer pays for all of these things. Buyer authorizes the buyer's lender and real estate agents and closing attorney to provide this contract to any appraiser if they need it, and to release and disclose the buyer's closing disclosure, settlement statement, disbursement summary, et cetera, to their agents and or the buyer's lender. This statement no longer applies. They had to add this statement early on because the Consumer Financial Protection Bureau, CFPB, said that the closing disclosure, the buyer was the only one that was allowed to see the closing disclosure. Well, if I'm the buyer's agent, I wasn't allowed to look at the buyer's closing disclosure, so I couldn't help them. So they added these statements to our contracts in North Carolina. But what's kind of stupid is that, I shouldn't say stupid, what's kind of weird is that the Consumer Financial Protection Bureau is a federal agency, which in federal always overrides states. But the state of North Carolina added this language to try to override federal, which is kind of weird. But anyway, no longer applies. Buyer can show you their closing disclosure. Seller has owned the property for less than a year, more than a year, or they don't yet own the property. Seller acknowledges that there are no proposed special assessments. Seller warrants that there are no confirmed. Now, I want to point this out. This statement says, to the best of the seller's knowledge, there are no proposed. To the best of the seller's knowledge, there's no proposed. But this one says the seller warrants that there are no confirmed. There's a difference. This is saying, as far as I know, there's no proposed special assessments, because remember, the buyer pays for special assessments. But this one says the seller warrants that there are no confirmed, because the seller pays for confirmed. If you are representing the buyer, you should check are not, and you should check are not. To the best of the seller's knowledge, there are not any proposed special assessments. Put the seller on notice. Prove me wrong. Seller warrants that there are no confirmed special assessments. Prove me wrong. Because if there are special assessments, you said there weren't, and there are. So you got to pay for them. Yeah. Contractor's license. Seller represents that the general contractor is licensed to construct. And it's probably a good bet that the seller should provide proof of that licensure to the buyer, probably before they go into contract, certainly during the pre-construction period, so that the buyer is comfortable. To the best of the seller's knowledge, there is or is not a homeowners association, which imposes various mandatory covenants, conditions, restrictions, yada, yada. Michelle, why are there two little boxes right here? Michelle, did she leave me?
No, I was muted, sorry.
Oh, you know why there's two little boxes here? Are they supposed to be up here? Yeah, they're supposed to be up there.
Probably when Dot Loop did it, they just put it in the wrong spot.
Can we get them to move those?
Yeah, I can move them. I just
Oh,
have to
cool.
go into it.
All right. And if there is an HOA. Now, again, as I said before, the MOG report is required if the property is in a neighborhood on a lot. The MOG report is required, but the RPODS report is not required because the house hasn't been built yet. But if the neighborhood has an HOA, then you must include the HOA report, which says that there is an HOA. You have to include the Owners Association disclosure, which is a separate form than the RPODS report. The only time you use the owner's association disclosure, the only time you use that is if the house is in the neighborhood with an HOA, but the house has not yet been built, so the RPODS report is not required. Or it's a spec home, a home that has never been occupied. You do not have to provide the RPODS report if it's never been occupied. If they're selling the model home, they have to provide the RPODS report because the home's been occupied. But if the builder is selling a spec home, they have to provide the MOG report, but not the RPODS report, Residential Property Owners Association disclosure. But if there is an HOA, then although they don't have to include the RPODS, they do have to include the HOA Owners Association disclosure, saying that there is an HOA. Seller has obligations. They have to provide evidence of title that they really do own the property. They have to provide a payoff statement. Seller agrees to use their best efforts to provide closing attorney by the effective date, copies of any insurance policies they had, opinions of title, surveys, covenants, deeds, notes, deeds of trust, leases, easements, blah, blah, blah. Seller shall provide to the closing attorney all information needed to obtain a written payoff statement from any of the lenders regarding any security interest in the property. Because remember, the builder might have gotten a loan to build the property, and that loan would be paid off when the buyer buys the property. So the builder has to provide to the closing attorney his loan information so that that loan can be paid off. Seller authorizes the attorney to disclose everything that they need, basically, so that they can get the transaction done. Not much more I want to say about that. Let's see. Seller will give the buyer access to the property, investigate, walkthroughs, things like that. Note the seller's obligations includes providing existing utilities operating at seller's costs, including all connections and de-winterizing. This is true for resales also, folks. This is true for resales. If you're using the standard offer to purchase contract form 2T because you're helping a buyer buy a resale property, that contract states that the seller will provide working existing utilities, which means that if the utilities exist on the property, but the seller has winterized the property because they don't live there anymore, the home is vacant, then the seller, at the seller's expense, agrees to turn the utilities back on so the buyer can pay, or so that the buyer can have their inspections done. So don't forget that. All our contracts state that it's the seller's expense, it's the seller's responsibility to have the utilities turned on so the buyer can do their inspection. And by the way, the utilities need to stay on through the buyer's final walkthrough, which could be up to, probably would be up to the day of closing, the day of settlement.
Terry.
Yeah.
Question on that.
Yeah.
So if it's written in the agent's remarks on the listing that they are not going to turn on the utilities, how does that all play out?
Nobody cares about the listing agreement.
Okay.
Yeah, that's a great question, Susan. But remember, the listing agreement is between you and the seller, between Wilson Realty and the seller. It has nothing to do with the buyer. Even if you put in the MLS, seller will not turn on utilities. If you don't make sure that that is clearly spelled out in the offer to purchase a contract between the buyer and the seller, then the seller will be obligated to turn on the utilities, even if they said in the MLS they won't. Because the only contract that matters is the one between the buyer and the seller. But you make a very good point, Susan. Buyer and seller could agree that the buyer will turn on utilities. I don't recommend that though, because if the seller is behind in utility payments, then the utility company is not going to turn on the utilities. Somebody's going to have to bring the seller up in arrears. And a lot of times, even if they're not in arrears, they're not going to turn the utilities on for the buyer because the house isn't in the buyer's name. So the seller sort of has to do it. So I would encourage sellers, even on the listing, don't do that because you agree to do it in the offer to purchase contract. You agree to turn them on. So I wouldn't even give the seller an option about that. Seller will remove all garbage and debris. And again, this is the interesting thing. This contract specifically states that the seller will have the property broom clean or swept clean. Our offer to purchase contract Form 2T does not state that. But in both contracts, it does state that the seller shall remove by the date of possession, which, by the way, folks, date of possession is not settlement. Date of possession is not settlement. It's not closing. Date of possession is the day the buyer moves into the house. That's date of possession. So it's possible that there might be garbage and debris there after the date of closing. If the buyer has yet to possess the property, then the seller's not necessarily in breach, as long as they get it out of there before the buyer possesses the property. Seller guarantees that there are no mechanics liens. This is 120 days, that they haven't hired some sub that they didn't pay. The seller agrees to have paid them. There might be a lien agent involved. The seller shall have designated a lien agent, and seller shall deliver to buyer as soon as reasonably possible a copy of the appointment of a lien agent, all deeds of trust, deferred, ad valorem taxes, blah, blah, blah. Sometimes what happens is you might have a builder that's building such a big project that you don't know who to file your lien against. Maybe it's a mechanics lien. And I'm a sub, I'm an electrician, and I'm doing work on a very large piece of property. And I don't even know who the builder is. I don't even know who's paying me. It's such a large conglomerate corporation. I don't even, because if I'm going to file mechanics lien because I didn't get paid as the electrician, I didn't get paid by the contractor, the general contractor, then I have to file my mechanics lien at the Register of Deeds, but I also have to notify the general contractor that I filed a mechanics lien. But if it's such a large corporation that I can't figure out who to file my mechanics lien against, then that corporation, that builder has to designate a lien agent, a representative that I can name in my mechanics lien so that I can file my mechanics lien. Builder has to do the same thing here. That most likely it will be them, but they have to name who is the person that if the sub needs to file a mechanics lien, who is that person that they can file the lien against. Now, this is the other thing that's different about this contract. Normally, when we use our offer to purchase contract Form 2T to buy a resale property, where I'm a buyer and I'm buying somebody's home that they live in, they sell that home under a general warranty deed, greatest protection for the buyer. But anytime that you buy a builder's property, if you're using the builder's contract, which 99% of the time you are, think D.R. Horton, think M.I. Homes, think whoever, if you are buying their property, their contracts virtually always say the buyer is going to buy it under a special warranty deed, a limited, which is that's what special means, limited warranty deed. And the difference is this: under a special warranty deed, when the builder sells you the house, under a special warranty deed, the builder is saying, I didn't screw up title. I didn't create a mess. I have paid for all the liens on the property. You, the buyer, are getting this free and clear. You're getting good, clean, marketable title. You won't owe anybody anything, and there won't be any challenges to your title while I, the builder, own the property. In other words, I, the builder, didn't mess up. What happened before I, the builder, owned the property, I'm not warranting. You're on your own. I'm just saying I didn't screw it up. That's a special warranty deed. A general warranty deed is saying I promise you, Mr. Buyer, I didn't screw it up. And if it was screwed up before I owned it, I'll still protect you forever. 30 years in North Carolina is forever. But this contract, interestingly, even though the buyer is building new construction, even though the buyer is buying new construction from a builder, this contract is selling the property under a general warranty deed, which I find interesting, because now that builder is saying, not only didn't I screw it up, but if there was a screw up before I owned it, I'll protect you. I find it interesting that they did that, but there it is. And they will convey feasible, marketable, and insurable title, and no mechanics liens, free of any other liens, any encumbrances, defects to title, defects to property, including those which would be revealed by a current or accurate survey. Ad valorem taxes, of course, don't count because they're prorated. Utility easements and unviolated covenants, conditions, or restrictions that do not materially affect the value. So in other words, if there's a utility easement on the property, it just runs with the land. I'm not going to protect you from that. The property must have legal access to a public right of way. It can't be landlocked. Deed, taxes, and fees. Seller shall pay all of those taxes and fees, such as excise tax, rollback taxes, local conveyance taxes, etc. I've never seen any of those other than excise tax. If the seller is agreeing to pay some of the buyer's closing costs, that'll go in here. If the buyer's getting an FHA or VA loan, make sure you include the FHA VA addendum. And note that the inspection costs cannot be paid by the buyer at settlement, and the amount of these should be included in the blank above. So if the buyer's getting an FHA loan, then whatever it's going to cost the buyer to have the property inspected, or other lender fees, then the seller has to pay those fees. Seller has to pay them. So do be careful if you're representing the seller when you advertise this property for sale. Are you going to be okay taking FHA or VA loans knowing that the seller is going to have to pay for the inspections? Owners Association fees, seller shall pay any fee that is confirmed, as we talked about. Not much else I want to say about that. Seller also will pay for any confirmed special assessments. Late listing penalty. This is in all of our contracts. Does anybody know what a late listing penalty is? They're funky. In a late listing penalty, technically, every municipality has to register what properties they are. Michelle, why did you send me a text? Am I not in the meeting anymore? Can you all hear me?
You are.
Okay, because you sent me a text that said you joining the meeting, question
Oh,
mark.
that was like at 9:55. I
Why
mean,
did you-
55.
Oh, it just popped up on my phone. Anyway, yeah, just FYI, everybody, I probably will be every 10 o'clock meeting. I'll probably be like 2 minutes late, but I'll be there. Every municipality in January has to list out all the properties they're going to tax for that year for real property taxes. It is theoretically possible that if you live in Mecklenburg County and Davidson is going to annex your property, it is theoretically possible that you could own the property in Mecklenburg County, not tell Davidson that you own the property. Davidson doesn't realize it, and therefore you don't get listed in January as a property to be taxed by Davidson. If that happened, then when you did finally file with Davidson, say, hey, sorry, I just want to let you know that I'm in your tax jurisdiction, I owe you taxes, then they could charge you a late listing penalty for not listing the property with Davidson in a timely manner. I have never seen that happen. but apparently that's something that theoretically could happen. So they include it in all the contracts. But again, I've never seen it happen. Owners Association disclosure. Like I said, if it applies, then you include it. Seller's failure to comply or breach. If the seller breaches, then the buyer can elect to terminate. As a result of such failure, the earnest money and any building deposit will be refunded to the buyer. But again, if the seller breaches, the odds are they've run out of money or they've run away. So good luck getting all those funds back. But theoretically, you could sue the seller and get all your money back. Not much I want to say about that. Proration and adjustments. Taxes will be prorated as normal. Risk of loss and insurance. Again, the risk of loss for fire, damage, etc., is on the seller until closing. Closing being deed recordation. All that's on the seller until deed recordation. During construction, the seller shall purchase all risks, builder risk insurance coverage, including theft and vandalism, malicious mischief, etc. So the seller has to get these insurance policies. So you want to make sure they get those. They will also provide a third-party liability insurance policy for third parties that come on the property, subs, inspectors, people like that. Possession includes all means of access to the property. Keys, codes, includes security codes, garage door, shall be delivered upon closing as defined in paragraph 1. Checks, if you have included an additional provisions, addendum, or there's additional signatures needed, you would check them here. We cannot draft addenda, so don't be writing things. Tax deferred exchange, if the buyer is doing a tax deferred exchange, or the seller for that matter, then you would want to make note of that. Again, I doubt you'll ever see that, but you could. If you're going to see it, you'd probably see it on the buyer side, where the buyer sold the property and now they want to buy a property to build, and they're rolling the funds into that, and they want to avoid paying taxes. Now they want to defer, so they're going to do a 1031 tax deferred exchange. If that's the case, you are going to want to inform the attorney, the lender, and you're going to get a third party involved that does tax deferred exchanges, such as the Starker Exchange Company. Starker Exchange Company does tax deferred exchanges, and they will hold the buyer's funds from the sale of their house and then roll those funds into the purchase of this home. This contract shall be binding upon and shall inure to the benefit and buyer their respective heirs. So if the seller dies, the seller's heirs are obligated to the contract. If the buyer dies, the buyer's heirs are obligated to the terms of the contract. If something is done, or excuse me, if something is not done and was supposed to have been done, but closing has occurred, and now the seller says, hey, you own the house, the deed's been recorded, I'm not going to do it. No, 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 no. If you agreed to do something, it survives closing, you still have to do it. This is the entire agreement. There's no side bets going on. Contract, any notice of information, any notice of communication can be given to the parties or their agents. Do you remember we talked before about agent equals client, client equals agent? If you communicate acceptance to the agent, you've communicated to the client, and now they're under contract. It's because of this paragraph. This paragraph says communication to the agent is the same as communication to the client. So if I represent the seller and the seller agrees to the terms and the seller signs this contract, and I call the buyer's agents and say, congratulations, the seller has accepted, the buyer's under contract, even if the buyer doesn't know it. Because this paragraph says communication to the agent is the same as communication to the client. This contract can be executed in multiple or individual forms. It doesn't matter. A day is a day is a day. There are no holidays. If you say 16 days and the 16th day falls on Christmas, then you're working on Christmas. And then your signatures. My favorite paragraph of every contract is this one. The North Carolina Association of Realtors and the North Carolina Bar Association make no representations of the legal validity or adequacy of any provision of this form in any specific transaction. In other words, we want you to use this form, but we're not making any promises that it's legal, but use the form. I just love that. Buyers sign, sellers sign. If it's an entity, then you put the entity name here. Buyer signs as entity, and there you go. Same for the seller. Same for the seller. Wire fraud. By the way, speaking of wire fraud, I want to emphasize this. I can't emphasize this enough. Please do not get in the middle of wire fraud discussions. Do not involve yourself at all. Do not. If you get, and one of our agents, this happened to them recently, and God love them, they called me, and I was very proud of them for calling me. The paralegal sent our agent the wire instructions and asked our agent to forward those wire instructions to the buyer. Do not do that. Do not do that. Reply back to the paralegal and say, I do not get involved in wire instructions. Deal directly with the buyer. I will not get involved. Do not forward it to the buyer. Don't forward it to the buyer, because if you get hacked, they're going to put you right in the middle of it. And in fact, I think it was in Kentucky. A ruling came out. An agent did just that. They got the wiring instructions of the paralegal. They simply forwarded it to the buyer. They had been hacked. Their email got intercepted. The hackers changed the email wiring instructions, sent it on to the buyer. The buyer thought it came from the agent. The buyer followed those wiring instructions. The money was gone. The agent, because they were relied upon as the person that forwarded the information to the buyer, even though they didn't give any wiring instructions, they just forwarded it on. The agent had to pay $186,000 because the jury found them, quote, 80% liable because they forwarded it. Do not get involved in wire instructions. Don't. Just don't. Don't forward it. Don't help. Just call the paralegal and say, I am deleting. In fact, even better, call the paralegal and say, I am deleting this email you just sent me. I am not going to get involved. You need to send it directly to the buyer or seller, whoever it is. Please don't get involved. Please, please, please don't get involved. Also, please, please, please use your Wilson Realty email. I know it's new to some of you guys, but trust me, the Wilson Realty emails are very secure now. We're using Microsoft Windows or Microsoft Office 365. It is an incredibly secure email system. Please do not use your Gmail. Don't use your Yahoo. Don't use Hotmail. You are going to get hammered on that if you use that. They're easily hackable. Plus, I don't think our errors and omissions insurance is going to cover you if you send from Gmail. So if you've not been using your email, please use your Wilson Realty email, because it's critical. The wiring fraud, the billions of dollars that people have been paying out, it's maddening right now. And if we keep playing this game by not using Wilson Realty emails, and we keep playing the game of being in the middle and helping our clients out with this stuff, it's just a matter of time. And we're going to get caught in the middle of it. And it's going to be a lawsuit. And it's going to be unbelievably expensive. So please promise me you'll start. And I know that some of you are like, I hate Wilson Realty email. I'm sorry. Get over it. It's actually really good now. Windows 365 is Office 365, international corporation. This is not a fly-by-your-night email provider. These guys know what they're doing. So please, please, please use your Wilson Realty email. Not much I want to say about anything else here. You all familiar with this, escrow, all that. Anything else I want to say about this? No, I think that is it. Remember, all of our contracts do come with a guidelines. They do come with a guidelines. The offer to purchase contract form 2T, this one, other ones, they all come with a guideline. I strongly encourage you, please read those guidelines because they're written in plain English. But that is it for the new construction offer to purchase contract. And again, just to reiterate, we only use this contract. We only use this contract when the seller owns the property and the seller is financing the construction of the home. If the buyer is buying the property, if the buyer is financing the construction of the home, we do not use this form. What form do we use? You would use the offer to purchase a contract for vacant lot and land to have the buyer buy the vacant lot and land, and then a separate contract that you would not be involved in between the builder and the buyer for the actual construction of the home. So that's what they would use if the buyer is purchasing, if the buyer owns the land or the buyer's gonna own the land. So, questions?
I would never use this contract. There's no way.
I think that's smart. And again, I agree with you, Ed. Again, the
Yeah,
only time
it
you
just-
would use this contract, the only time you would is if you, for some reason, are representing a builder or you're representing a buyer and they want to buy property from a builder that owns the land and the builder is going to build the property, but the builder does not have their own contracts.
Mhm.
This is the only time you'd use this.
Yeah, I've done a few new constructions and most of them have their own contract, which spells out everything and you're basically agreeing to everything. And the one I did as you know, with a builder, just private builder, we actually used the 2T form and an addendum that showed all the changes. And he just had, the builder agreed to just get a due diligence fee or actually earnest money with the change orders money in it. And the way we structured was basically you have to have all the utilities and everything turned on about 2-3 weeks before closing. So we get a home inspector actually go in there, and I would urge everybody, don't assume because the building inspector went through and gave them a CO or they did a framing inspection, mechanical, that it's done. In North Carolina, you need a 70 to pass, okay? So you can get 30% off and still get a CO. So we made sure everything was done, all the utilities were on before we got a home inspector in there, did that, and then any items had to be fixed before settlement date. We didn't give them an option of, you know, you got whatever, you can do the punch list afterwards, you know, the cleanup, everything had to be done before settlement date. And we did an inspection a few days before that to make sure that everything was done. Because I mean, I've been in business of construction one way or the other. I used to build houses. They used to do remodeling. I've sold and bought real estate for investment. And now, of course, I'm an agent selling for, but you know, it's been my experience that sometimes you get into something and the builder goes belly up, especially little builders or something. And next thing you know, you have no recourse really. And we never, you know, the builder actually built the house with its own money, whether it was by the bank or whatever. He financed the whole thing. We did not give him any draws. The only thing he got was earnest money up there, plus the changes, which were about $5,500 or something like that. So we did that, but they were refundable because I put my due diligence period way up front. You know, I was like within a couple of weeks to, I think it was about 2 weeks before closing. So it allowed us plenty of time to make sure that he's got a CO and you know, all the inspections off and everything else like that. I prefer to use that you know, that method because basically you're buying an existing home once, you know, real property once you get there. And the builder, myself and the buyers all got together, we negotiated, more my buyer kind of negotiated what he wanted, because most builders will have certain plans that they build. You know, unless you're a really high-end custom builder, then they get an architect or something to do it. They got certain specs, and this builder did have certain models that he was building. He just changed some of the finishes and stuff, and those were the additional changes that he wanted to get paid for up front. So commit to it. But he basically the addendum was drawn out by his attorney. And then both the builder and the seller, or the builder and the buyer, signed the agreement to it and became part of the contract. But the rest of it was pretty much done just like a 2T, because I think it's better for the buyer because it protects the buyer more than it does the builder. This form has got so many things that it does give a lot of builders a way out, and it's very confusing.
Well, yeah, hopefully I unconfused it a little bit. That was the intention.
Yeah.
But the one thing I want you to be careful of is again, this form is really used for builders. And I think you're right, Ed. It's really more for those small time builders that don't have their own contracts, which scares me in and of itself, because anytime you have a small time builder, it's like, are they even going to finish? But here's one thing you want to be very careful of if you're using the offer to purchase form 2T, which I'm not going to say no to, but I really want to explore them more, is this: it doesn't come with a warranty. This contract, this form 800T, specifically spells out a 1-year warranty for the buyer.
Right.
But
Well,
if the
our
builder-
addendum did have all that in it.
Yeah, I mean, if they have their own warranty, you're probably, but if they didn't, and you use form 2T, now your buyer just bought a property with no warranty.
No, you got to have it written out as part of the change orders, or what do you want to say? It's got to be spelled out. Same thing for the streets, whether they're they're approved or accepted by the county or
Sure.
by the city, I should say, and or DOT or whatever. So I found that was much easier for my contracts to really understand. And that's at the time when I did this was through Keller Williams. And that's where my BIC said, don't even use that 800 form.
Well, I wouldn't. Yeah, I would be careful about that. I mean, there is a reason this form exists, and we shouldn't ignore it just because it's a little bit confusing. But I understand your point, Ed. I do. But we just really want to be careful, because if we use the wrong, here's the concern. If we use the wrong contract, and technically using form 2T is technically the wrong contract. If we make a mistake, then it's on us. Now we have to deal with that because we were the agent that used the wrong form. So maybe if it's like, I'm going to be helping a buyer buy a property that's owned by the builder and builder's funding it. Give me a call, give Darren a call, and let's talk about it before we go further. But you make a really good point, Ed.
Yeah.
So,
well, I think the reason I was told that is basically if you agree to the addendums and if some, an attorney drafts a manual, the buyer signs it, the seller or the builder signs it, basically at the end of that period, you're actually buying real property because he's got a CO. He may not have lived in it, but you're buying almost like a existing property.
no, I understand.
But you got to have all all the stuff spelled out on something else that's not covered in 2T as far as warranties and all that.
Yeah, that's a good point. But if you guys do find yourselves in this situation where you've got a buyer's going to buy a property owned by the builder, and the builder's going to finance the construction, just give me a call before you go forward.
Yeah. Well, normally what I did is when I did this, all the addendums and everything that was agreed on and the contract, I just had my BIC actually review everything to make sure, and that's what I would do. If I run into this thing and I'm thinking about using the 2T, I'm going to basically have Darren at least look at it and go like, Darren, do you see any problems with this?
Perfect.
You know what I mean? Because I think it's like you said, there's a slippery slope there. I mean, you can get in trouble real easy if you don't dot all your I's and T's.
And I'll
So-
tell you, I agree with you, Ed. I don't like this thing because what this form is telling me, 800T, let's think about it. The only time where we use this 800T is when the builder doesn't have their own contract. I mean, that right there scares the bejesus out of me, that you've got a builder that doesn't have their own contract yet. I mean, we're just asking for trouble.
Yeah, yeah. And the other thing too is with all the draws and everything that the contract is in it, the only thing I'd really be concerned about is, like I said, you can give him all these draws as you go along. The problem is if he still doesn't deliver at the end, if the builder owns the property, the land, it's very hard to get that property. Very hard. It's 9/10 of the law, basically, is possession. And so I would never, I mean, if I was doing that, I would say I buy my own piece of land, get my own contractor, and they become basically a sub for me. And I would give them draws when the footings were done, maybe when, the framing inspection was off, mechanical inspections, all that type of thing, because you're giving him a bunch of money for something that if he owns the land, and he's going to build the property, he should finance that 100%, maybe for, you just pay him for the extras because you're doing something above beyond his plan.
Sure.
Anyway, that's I always looked at it, when I was building myself because as a homeowner, you can actually build your own house. You can be your own general contractor.
Sure.
In North Carolina, in most states. And so I did draws as they got the insulation inspection off and, they got the painting and some of the finishes done, and then that 20-30%, it was at the end when we got the CO and all that and everything settled. I think you got to be careful with new construction because look what happened in 2006, 7, and 8.
Yep.
Okay, a lot of people lost a lot of money where the builders, even large tract builders, walked away. The bank owned everything. So try to get your money out of that.
Yep. Any other questions? Thank you, Ed. I appreciate that. Any other questions? All right, guys, go forth and multiply.
Yeah. Make the money grow,
forth.
right?
All right, man.
right.
Thank you so much. Next Friday, what I'd like to do next Friday is talk about the most common offer to purchase, and that is offer to purchase contract form 2T. They've made a couple of subtle changes to that one, and I want to make sure we're clear on that. So anyway, great to see you guys.
One more question, looking at the 2T and all that. I know it's got the DPA listed in it now, where you got to disclose if you're going to get financial assistance and all that. But I don't know if anybody else has run into this. Some of my lenders stopped doing those DPAs because of the forbearance clause or whatever. So they're worried about they can't sell the mortgages on an open market like Fairway, Movement Mortgage, Atlantic Bay and all that. They pretty much stopped doing those. There's probably about 90% of it. Has anybody run into that at all for first-time buyers? Maybe they want to use the financial assistance like the NC money.
I guess not.
Okay.
We'll talk. That's okay. We'll talk about it more next week. So next week, we're going to do the offer to purchase contract form 2T. So you guys have a wonderful week. And if you need anything, please reach out. And remember, use your Wilson Realty email.
Use the password reset. I can reset it for you.
There you go. All right, Michelle, you got any closing thoughts?
No, that's all. I'll once this updates to the cloud, then I will make a link and send it out to everybody.
Yeah, maybe make a post on Facebook that it's available.
Yeah, I will.
Okay, great. All right, guys. Great to see you.
All right.
Bye.
Thank you. Bye.
Bye.